Okay, so I
All
can.
right, welcome back to the House. June the 22nd of April. And we're going to turn to S-109, our miscellaneous bill, some amendments to kind of get us up to date on what we're doing with that bill.
Yes, thank you, Eric Fitzpatrick with the Office of Legislative Counsel here. As the chair mentioned, to talk about a new draft of the annual Judiciary Miscellaneous Bill. S-109 is the number this year. And there have been some proposed changes from the previous time that the committee talked about the bill. And you may recall that the changes between the previous draft and the draft before that were in yellow. So now I've chosen a new color, green, in case anybody wants to.
Wow.
Exactly. So sort of, I think if together they'd be brown, right? Green and yellow make brown. So we don't want to use that for the next color because you wouldn't be able to see the underlying text. I won't do that. Well, hopefully, if we get to the point where people, there's some consensus about where it is now, then we might be able to remove the highlighting for purposes of the next. But we'll see where you're at.
Ideas on color,
Yeah.
those Skittles.
All right. So like
green
red,
is-
maybe?
So green's to move it forward and red would be to stop it.
That could be, all
Give
right.
me the red.
All right.
Is there green in here that was not initially yellow?
Not initially yellow. That's a good question. Yes,
Wow.
yes. There was some green that was not in here at all before.
That would mean it wasn't.
So that was not yellow at all.
Yeah.
That's right.
Okay.
Yeah.
Great. That'll help me.
In fact, the very
suss
first
out
change, yes. In fact,
What's happened?
the first example of that is on page 6.
Oh, yeah.
The first change, yes. So you see, this has to do, this is the situation where with respect to the Victims' Compensation Board, they've been getting some claims for compensation from interveners. In other words, it's not a person who's actually the crime victim, it's somebody who intervened in an attempt to try and provide assistance to the victim. And the proposal initially was just as you see in line 8 on page 6, is just to clarify that an intervener, as opposed to the victim, who can be compensated for both physical and emotional injury, but interveners, to clarify that they can only be compensated for physical injury. But it does, the new proposal, the new language is in green, because the way it's phrased currently is that the intervener has to be can only be compensated if they try to assist either the victim or the police, right? So the proposal is to expand the police term to any protected professional as defined in the assault statute related to protected professionals. And you may recall what that statute is that it provides a heightened penalty when the victim of an assault is a protected professional. And that, I'll read it to you. Who are those protected professionals, you might well ask? They are a law enforcement officer, a firefighter, a healthcare worker, an employee, contractor, or grantee of DCF, or any emergency medical personnel. So that's, over the years, the Judiciary Committee has added on to that list on several different occasions. I think it was initially a law enforcement officer. Over the years, you've added on to a couple of times. That's where it sits now. So the intervener who tries to help when there's a crime being committed can be someone who tries to help not just a law enforcement officer, but any one of those other professionals that I just listed.
Could it be military as well?
Let's see. Not in the definition currently. But could it be? Yes, if you add it, you could certainly add it. Yeah. If you did so, you probably would want to add it to the assault statute, not here. All right, so that's the first change between this draft and the previous one. Any questions there? Any additional questions? Move on. All right, so page 7, the next page you see is just a section that's struck. This green was also not originally yellow because it was originally just language that was in the bill. Now the proposal is to remove it. And the reason you may recall is that this has to do with the situation where a stalking, an order against stalking under current law still has to be served on a defendant, even if they were physically present in the courtroom when the court issued the stalking order. But to make this consistent with relief from abuse orders, you provided that they can be mailed to the defendant if they were actually sitting there. However, this entire section, I think, well, for sure it was in S9. I think you guys added it to S9 when it was over here. So in other words, it already appears somewhere else. So I think S9 is, open, I guess. I'm not positive if it's past if they've concurred yet. I thought it was S9, but
That's not, yeah.
and I'm not sure the status of that. In other words, whether the Senate is passed it, sent it to the governor yet. But I can follow up on that. In any event, once that does happen, which presumably it will, then there's no need to have it here. So it will already be passed there. All right, that's that. Then we move quite a bit ahead. I believe the next there's one other, actually, here's a change I noticed. So it's over, we're talking about pages 15 and 16. And this is you may recall, this is the provision that you currently have. It's in real estate law, where if certain instruments that have to do with the chain of title and real estate transactions have been in the land records for a long enough period of time, then they are validated. There's the statute that validates those. Sometimes it's 15 years, sometimes it's 3 years, but the idea is that if the document has been in the chain of title for a long enough period of time and it hasn't been challenged by anybody, it hasn't been subject to any legal challenge, then it's going to be viewed statutorily as valid. So the proposal is to add a new situation, and this is when you have a deed or some other document, some other instrument purporting to be transferring real estate under a power of attorney, but the power of attorney actually isn't in the land record. So it refers to the power of attorney, but it's not there. The title search doesn't turn it up. So that's what this one is adding to that. In the existing law, you have another provision that says, okay, if you have the deed and you have the power of attorney, but there's some technical problem in the power of attorney, that's subsection E on page 15. That's existing. That says, all right, then we're going to validate that deed or whatever, even if there's been this technical problem, as long as it's been on the books for 3 years and nobody's challenged. And there's a sentence at the very end of that. This is existing law, line 14, page 50. It says, this subsection shall not apply to a power of attorney obtained by fraud or forgery. So in other words, if there's this mistake in there, generally speaking, you validate it after 3 years, but that sentence says, well, yeah, but if there was a fraud or forgery involved, then you're not just going to say it's valid, right? So the idea was to add that sentence to the new provision, this new section that the bill adds saying, hey, if the power of attorney is supposed to be there, but it isn't, nobody challenges it for 15 years, then it's going to be presumed valid. And that sentence is in green on lines 4 and 5, but I realized it needs to be tweaked a little bit because it just restates the sentence. This subsection shall not apply to a power of attorney obtained by fraud or forgery. But there isn't a power of attorney in this case. It's supposed to be there, but it isn't. So it should read, I believe, the subsection shall not apply to an instrument obtained by fraud or forgery. So the idea is that it's the other instrument, the deed or whatever that refers to the non-existent power of attorney. As long as it's not done by fraud or forgery, then it's validated. As long as if it's been sitting there in the land records without challenge for 15 years.
So that'll be the new color.
I'm hopeful it will be clear. In other words, no color. With any luck, that the next draft will no longer have highlights. But that's the goal. Okay, but that's totally up to the committee. All right. So moving on, we're now getting to the firearm surrender compliance working group. That starts on page 18. Number of changes here. You'll see in green. The first one, this is the working group that's established that is convened by the Office of the Attorney General to develop this uniform process to ensure compliance with court orders to surrender firearms. Remember, there are these surrender firearm orders that require surrendering of firearms that are in existence in different parts of the statutes, whether it's relief from abuse orders or emergency risk protection orders. A couple of places, actually. So the idea is to try and develop some consistency among how these firearms are handled and stored. And you'll see in line 8, I think the committee took testimony that there was also concern about the return of firearms also be addressed. Not only the storing, but the return of them to the owners, because oftentimes they will be returned, for example, after the RFA has expired or after the ERPO has expired. then sometimes the firearm will be returned. So adds the words "and returning" to line 8. There was also some discussion about who's going to, because you've divvied it up into two groups of people. One group of people is on the working group, and there's another group of people with whom the working group is required to consult. So there's been some proposed switches between those two groups and some additions as well. But first, you'll see line 13, page 18. The Attorney General is identified as the chair of this working group. So that's the proposal there. And then you'll see the next two changes, bottom of page 18 over on the top of page 19, both the member appointed by the Vermont Council on Domestic Violence and the member appointed by the Vermont Center for Crime Victim Services those two members are moved from the membership of the working group down to the list of entities that have to be consulted. So that's over on now over on the top of page 20. And now that I think of it, we probably don't need a member there, right? They're not consulting with a member, they're consulting with a group.
Yeah. Yeah.
All right, so that's the proposal there. Move those two entities over to the list of consultees. You'll also see that, and this is over on page 19 now, look at two different places. So previously, in the previous draft, the list of consultants, which starts at line 9, included, you see, this is line 12, law enforcement, a rather general statement, who to consult with. So that's been moved up to the list of people on the working group, and that's at line 5 now, a police chief appointed by the Vermont Association of Chiefs of Police. So the idea is strike that rather vague language about law enforcement and instead identify a particular law enforcement officer to be part of the working group. That's what that does. And you'll see now, if you kind of have to look at these two things in conjunctions, which is line 7 and line 17 of page 19. So the idea here is that you have two people who will be part of both or I should say either the working group or the list of parties consulted by the working group. And this is for you to decide. But the options are, so you've got these two people representing the firearms groups. One would be a federal firearms licensee, and the other is a member appointed by the Vermont Federation of Sportsmen's Clubs. So the idea is to have one of those two folks be on the working group, and whichever one is not on the working group would be listed in the folks who have to be consulted. So at the moment it says or, because I think it leaves open to the committee to decide amongst yourselves and with whoever you want to consult with, which one do we want on the working group and which one is best among the parties to be consulted.
Kevin.
Was the FFL originally appointed by the Attorney General, or is that new language?
That part, thank you for catching that. Yes, that part is new. Because there was, if the person is going to be on the working group, they've got to be appointed by somebody. Because it has to be a way, you always have to have a way to pick the person. So that was the suggestion as to who could make the appointment. But it doesn't have to be that. It could be whoever you think, whoever can make that appointment.
Who can?
It's a tricky one. I'm not totally sure. Maybe you could ask them, who they think, or ask.
They're not going to give me any names. They want to do it themselves.
Who?
The Attorney General.
No, or yeah, ask them or ask the licensee.
The Attorney General is not going to want to give me any names. They want to do it themselves. So.
Oh, well, this would, if you put that person
for guidance.
Oh, well, this would require them to give you a name.
Oh.
No discretion. It's not a may, it's a shall.
It's.
Yeah. Well, I like that word.
There you go.
Okay.
If you choose that route.
Oh, I'm all in favor.
All right, there we go. So that's decided. So that concludes the membership piece of it. There's also a little bit of additional language over on page 20 to the report. And it's consistent with this idea, as I mentioned earlier, about returning firearms, but this expands what's going to be in the report. So not only does it talk about the statewide compliance model with reference to the accountability of the respondents and defendants while addressing safety needs of plaintiffs, that's lines 11 and 12, but it also has to include a provision about proper storage and return of firearms that are surrendered pursuant to court orders. So this working group would also look at that, how there could be this statewide consistent model for compliance with standards about storing and returning firearms that get surrendered pursuant to one type of court order or another. And a little bit more on the second, not working group, but I believe this one is a task force.
Yeah. So if we are going to have an FFL or somebody from the Vermont Federation of Sportsmen's Club, presumably those individuals might be entitled to a per diem because they're not there. I mean, the Vermont Federation of Sportsmen Clubs, I don't believe that they have paid individuals. I don't think. I mean, FFLs, they certainly are paid, but not paid to go to be a member of such a way.
Right.
So we're probably going to have to add the language, essentially the language that we're taking out of the other place. We need to probably put in here.
Right.
The six here.
6 meetings.
6 meetings.
Yep.
And the other language we're going to have to put into here because those are individuals that would be entitled to a per diem.
Sounds good. So we'll put that in for the next draft also. So yeah, speaking of that other study, that's a victim notification system task force. It starts on page 26. Remember, this was the idea of having a task force improve the responsiveness of Vermont's victim notification system. And this adds, yeah,
You're on page 26.
yes.
Can we? Sorry to do this.
Yeah.
But did we discuss the language in section 26 on page 20? That,
Page 20?
yeah, that didn't, I don't recall, but that didn't, like on line 18, we didn't, did that bring up a lot of discussion?
That one in particular did not, because you may recall, this is actually a reenactment of statutory language that was repealed last year. So actually in the miscellaneous bill, as it happens. So last year, that language that you see over on page 21, lines 11 through 13, was repealed at the request of DCF, because they took the position that that someone's financial means is not generally something that would be taken into account with respect to DCF terminating parental rights. But as it turned out, that change led to quite a bit of response from family law practitioners who pointed out that, well, this language here doesn't actually have anything to do with DCF's termination of parental rights. It has to do with separate situations involving divorce and dissolution of marriage and those situations in which it actually can be relevant, whether or not someone has made child support payments in the past. And so I wasn't here for did DCF ever testify on this?
They have not yet.
Okay, so I'm not sure about that part, but I think that there was some consistency in the response that the language shouldn't have been deleted and that it actually is relevant in these types of situations. And the DCF is not generally a party to these types of proceedings anyway. So that's the upshot of it. It's reinstating this language that got repealed last year. And I don't recall there being a ton of discussion about it, other than that I think you heard from at least one attorney in private family practice about putting the language back in.
So are we going to have DCF or it's not really anything? It's not a,
Yes, we are still gonna have DCF here. Or they're gonna send us an email and say, yeah, we don't have anything to do with that section. Whoops.
but they would, wouldn't they?
They would what?
Have something to do with that section, section
Well, I
27.
would like to understand why they suggested taking it out last year when it's not something that they deal with. So yes, but thanks for the reminder. Yes, DCF we were scheduling them and then they weren't able to make it when we tried. So we'll have them in.
Yeah, I mean, just me, that
No,
seems
no,
like a
we
hot
need to,
button topic.
right, we need to close the loop on that. Yeah, we will.
Thank
I'm
you.
good.
Thank you.
Yeah, nice catch. So, that brings us back to the Victim Notification System Task Force report on page 26, which again is this task force to look at improving responsiveness in the victim notification system. Proposal is that it's a relatively small group, particularly compared to the other one, but the proposal is to add a couple of more members. That's over on the top of page 27. One member appointed by the Network Against Domestic and Sexual Violence, and the Victim Services Director of the Vermont State Police. And as the chair mentioned over on page 28, because this group wasn't going to have any paid members, there's no reason to have the compensation and reimbursement subsection on line 9 or the 6 meeting limit on page 6. So that's why these are struck here. But you'll see that same language reappear in the previous report that's just indicated. And I think that's it. Although I did see, for example, on I was in House Corrections and Institutions for most of the afternoon, so I didn't have a chance to make the change yet. But I did see some language that you sent me to think about this last section, section 33, the Adult Involuntary Guardianship Working Group. So
Right, from Ann Donovan.
yes, exactly. So I can add that to the next draft as well. I think the idea there, if I got a quick chance to look at it, is this is the one where the working group is going to look at whether or not to consolidate the 2 different types of adult guardianship proceedings that you have going. You have one in-law for adults with developmental disabilities that's in the family division, and you have another provision that's another chapter that's in the probate division that deals generally with adult guardianships of adults in other circumstances. And the idea is to try and think about whether they should be consolidated. I think the proposed language is also to think about, well, either consolidate them or perhaps make statutory changes to make sure that the rights of the persons under guardianship are similarly protected in both kinds of proceedings.
It slightly broadens what they're to look at.
Right. Right.
All right, any other questions for Eric? Well, see, now we'll hear from Todd Dalos from the Attorney General's office if he's willing to weigh in on FFL versus Sport Federation, if there's any input you want to provide us on that today, if that's okay. Here.
Good afternoon, Todd Delos, Assistant Attorney General. To answer the question, Mr. Chair, I think we would advocate for an FFL. We've been in touch with some of the FFLs already to try and figure out if we can find members who would be willing to serve. And I think that's consistent with the testimony last week with the Sportsman's Club too, that what we're looking for here is the operational knowledge of how this system could work better. And so that we support that with certainly consulting with the sportsman.
Any questions for Todd? Ian?
Have you spoken to any that would be willing?
Yeah.
And they'd be willing to be a member, not just a consultant?
Yes.
I initially had contact, I think, with the Sportsman's Association. On this, they came to me. They're interested in the whole package and not just the storage part of this. as sort of an oversight, I agreed, that's why I sort of invited them. But the FFL does make sense, but I think their part would be much lesser. Operationally, it's. But it'll work.
Yeah, I, again, feel like we got a pretty good, in my experience, new working relationship with the sportsman, but I'm more than happy to stay in touch with Chris.
Any other questions? All right, thank you very much, and thank you, Eric. So we're adjourned until tomorrow at 9.